What's up, everybody? Welcome back to another episode of The Lawyer You Know. And today seems to be a day that we had a lot of lawyering and a lot of legal issues, not a lot of witness testimony, not as much as we've had on other days, decisions made by the judge, actions taken by the lawyer that could have some very serious effects on the future of this case, the appeals in this case, where if there is a conviction, you can guarantee there's going to be an appeal. What do I see? What do I think? I think there's some things you're absolutely going to agree with me on and probably some things you don't, but at least stick with me. Tell me why you agree. Tell me why you disagree. Let's get into it. So in case you want to know how everybody's feeling about this case, I have a sheet where I'll put titles and subtitles in for Kelsey or John, whoever's going to make the video. And I put Karen Reed trial 2, day whatever it is, assuming they would look it up, but it just ended up getting in there as day whatever it is, because day whatever it is in this trial at this point, right? We're almost into 30 days. The defense is getting close to finishing their case in chief. And the Commonwealth has let us know, so it seems from reports, from what it sounds like in the courtroom, that they're going to call some dog DNA specialists, Dr. Crosby, to refute and rebut the dog bite information and testimony that's coming in the defense's case in chief, and of course, Dr. Welcher. So, I think that's 1 to 2 days of testimony. The defense thinks they're going to be done Tuesday. I still think they will. We've got Dr. La Posada, who's still on the stand at the end of the day today, that will go maybe half the day tomorrow. Then Dr. Rentschler, maybe half the day. Maybe they bleed into Wednesday. I really think we could have closing arguments by Friday. Maybe the judge will give the jury the weekend off and bring them back to start deliberating on Monday. Maybe they'll start deliberating on Friday. People are saying Dr. Crosby's not being called. I thought Dr. Crosby is being called. Dr. Crosby's not coming in. Did she make that decision? I don't know. I thought Dr. Crosby was going to be, Brennan said no Dr. Crosby. That's interesting. I must have missed that. Ooh, isn't that interesting? So no Dr. Crosby. They're just going to bring in the non and lack of dog DNA. I never really understood how somebody's going to get up there and say these are not dog scratches based on my education experience, but that is incredibly interesting. I love when I hear things and get to react to them just right on the spot with you guys. So no Crosby. So Brennan is trying to simplify the rebuttal / what is the defense of the defense, basically. So that's interesting. That's really interesting after all the fighting we've had about Crosby. So regardless, we're going to have Welcher and we're going to have some dog DNA people, maybe some other things, but that's a day maybe. How does that even bleed into 2 days? So I'm thinking Thursday, I feel like we're going to be done with all the testimony. She should give them a break and then maybe come do closing Friday morning and give the case to the jury Friday afternoon. Wouldn't that be crazy for the weekend? But a lot happened today outside of the witness testimony, and it started in the very beginning where they argue that the defense should not, the Commonwealth should not be able to bring in the dog DNA because they knew the defense was going to argue it and they chose not to bring it in their case in chief. I tend to agree with the Commonwealth and the judge's decision, which she did allow them to rebut the defense's case. It's a new trial. We know what was argued in the last trial. A lot of things changed this trial. We know what was said pre-trial. Lawyers make these strategic decisions. So the Commonwealth didn't know for 100% certainty that the defense was going to bring in the dog bite stuff. I think we all could have figured that. But until it actually happens, they're allowed to bring it in rebuttal. There's no reason they had to bring it in on their first case in chief. Now, I will say, if they were going to cross-examine on it, they should have brought it in their case in chief. But outside of that, just taking this decision that they had to bring it in their case in chief, therefore they can't rebuttal. I disagree with that argument. I agree with the judge saying, you brought it up in the defense case in chief. This is exactly what rebuttal is for. The Commonwealth does not have to guess to everything you might argue and go on the offensive in their case in chief and try to bring all this stuff up. So I agree with the judge and the Commonwealth on allowing the dog DNA to come in and rebuttal, even though they didn't bring it in their case in chief, because it is rebutting an argument made by the defense. If you guys disagree with that, that's fine. That's how I view that personally. Now, La Posada, and they were arguing different limitations. This is not the point in the day where she made the decision on La Posada, but she did say to Brennan, I know what I think, but it's the Commonwealth's motion, so let me know what you want to limit. Meaning she read through and already determined what she thought she should limit from La Posada before the Commonwealth even made their arguments. So we're going to have more of voir dire at some point with that. But eventually we get back to Dr. Wolf. Wait, who's back on the stand? Sorry, there were some other arguments, but let's get to Wolf. So we talked about photos of the test dummy. They showed last week. They pull up on the screen again, and they talk more about the injuries and the cuts. I shouldn't say injuries. The holes or imperfections in the garment in the sweatshirt. And Jackson very smartly points out this is the left arm. This is road rash. There's road rash on the face, on the torso, on the back. He makes it clear, not the same kind of puncture wounds on John O'Keefe's sweater. I think without a doubt, the defense looked at everything on social media this weekend and saw a lot of people saying, after all those experiments and tests, I kind of have it in my mind how this is possible. That it got hit by John O'Keefe's arm, got hit by a car, shattered the taillight. How the taillight could have ripped through his sweatshirt. And if it could rip through his sweatshirt, then it can scratch his arm. And to simplify it step by step. And to me, Jackson did a really, really good job of making sure the jury understands it is not the same thing. This is not the same thing. This is road rash. This is from dragging in the street. These are not puncture holes caused by the taillight. So let's listen to a little part about Jackson and Wolf discussing exactly what these holes on the sweatshirt were from. So somebody just told me it's not on screen. I'm sitting here just watching it by myself. So let me go ahead and put this back on screen. I don't know if you guys can even hear that, so I'm going to back it up. Was it fun, everybody, just watching me watch the video? So here we go. Let's try that again.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
So I'm still seeing no sound. I know the chat's a little behind where I'm at. Hopefully you guys can hear this, but Jackson is like, well, what are these fragments right here? Now, to me, those look like parts of the road more than they look like shattered glass. But Dr. Wolf says they're part of the shattered back window that's shattered, which is obviously very different than what happened in what the Commonwealth's theory is of this case. But nevertheless, I think Jackson thought he was going to say those are part of the road, but he didn't. He said they're part of the glass, and Jackson adapts, and he continues to go with this road rash theory.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
It's clear Jackson thinks it's from the pavement. He's trying to get his witness to pick up what he's putting down. The witness is not. And frankly, all this means is the witness is trying to be honest. He's like, it looks like he's like arguing with the lawyer that hired him. He's like, I don't know. It looks more like glass than it does pavement. So it still works for the defense to say it's different, but it doesn't work as well for sure as if it is pavement. And additionally, there are some pictures here that Hank Brandon picks up on, and I think does a good job saying there's glass, there's plastic, the shards are by the body. And there's a million possibilities of what could happen in this test, but you are showing a bunch of scenarios where it gets hit by this and the debris ends up right next to the body, which is exactly what we're saying. Continue to give the jury a visual of your theory. If you're Brennan, that's what you need to do. And by the way, I got to be complimentary of Brennan now because stuff's coming later. Okay. Stuff's coming later, but I'm still going to try to point out what he does well on with these witnesses.
What was the condition of the back window after this test?
It was completely shattered.
And that's why that was a great follow-up question by Jackson. Remind everybody what the back window, what happened in this crash, where there ended up being shards of glass around the body, right? If we're going to say this is the same, it's actually not, because the back window was completely shattered. Completely shattered, which did not happen in John O'Keefe's situation. Okay, next we have more photos of the shirt with holes everywhere. And this is photos of the Crash Dummies shirt. And Jackson is like, where did these holes come from?
Is it 220?
Permission to display.
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29-mile-an-hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
And Jackson didn't show it to him last week either. Okay, so you see all the holes in the road rash, and Jackson's going to point it out. It's all over his body, because when you're hit going that fast, you can fly and skid across the street. You might land on your face. You might land on your back. You might tumble. All sorts of different things. But look at how destroyed this sweatshirt is. Like, don't get too caught up in the minutiae. Now, listen, there's parts where the defense really wants you to be in the details. There's parts where the Commonwealth wants to simplify it. But then there's parts where it goes vice versa, where the Commonwealth wants to focus on these little details. Look, there's a piece of plastic here, a piece of glass there. And the defense is like, this dude is destroyed. If you get hit going 25 miles an hour and you fly across the pavement and you slide across the grass or whatever it may be, there's going to be evidence of that. And the evidence is going to look like this, not like a dog bit or scratched your arm. That's not what it's going to look like. And I thought Jackson did an amazing job on this redirect of making sure to actually show the pictures. Because last week or this weekend, whenever we talked about it, days are running together, we were like, if there were pictures, I wish he would have shown the pictures. And it feels like there would be pictures. Well, neither side entered them. And you can say Hank Brennan didn't show them all you want, but now the defense gets to show them.
Caused the holes in the bodice of the shirt. In other words, the part that covers the chest and the torso.
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
All right, you get the gist, but he did a really good job about it. Then they do this math. Is it 21% or 26%? And what difference does that make? But generally, Jackson's like, you did it at 29 miles an hour. So at 24 miles an hour with a heavier weight, the damage would be somewhat similar or maybe even worse because the weight's heavier. When the weight goes up and the speed goes up, the damage goes up. I get it. Fine. That's what he ended on. Wasn't as crazy effective to me. I know a lot of you guys, you noticed that math problem before. And guess what? Jackson used that too. So what the public is talking about is so important in these cases. When I spoke to the FACDL, the Florida Association of Criminal Defense Lawyers, you would be shocked at who was in the room. All the guys and gals that are hired on the high-profile cases in Florida that you have watched on YouTube or you will watch on YouTube in the very near future. Okay? Some handling appeals on cases, some handling the trials, some handling second trials. And they're coming up to me like, can I call you during this? I want to talk to you and see what your people are saying. What does your chat think? What does the public think? And I'm going to have somebody watching all these different social media channels following what the people are saying. I was like, hey, chat's wicked smart, like Ashley said, wicked smart. And I talked to him about only a couple times the chat's been wrong when they're voting on how this is going to go. These defense attorneys are watching. I've never been more confident in that than I sit here today on June 9th of 2025. After the experience I had this weekend, I couldn't believe it. They were taking pages of notes because this stuff is important and it is going to affect our system more and more in the future. I don't care what anybody says. I don't care what anybody says about fake lawyers or wannabe lawyers on YouTube or lawyers that don't practice anymore or blah, blah, blah. They can say whatever they want. This stuff is important, and how the public views it is important. And I promise you, Jackson or somebody on his team is watching. And I don't mean this channel. I mean generally what you all are saying publicly, because it's making its way into directs, cross, redirects, recross, and arguments. It's important. And people are picking up detail. One of the lawyers came up to me and he's like, a bunch of people in the public are reaching out to me and they're just like sleuths. They're not lawyers. And it's crazy. He's like, it's hard for me to sift through everything, but I'm doing it because they've thought of things I would never think of to argue. And this is somebody trying a second case. So he already has everything happen in the first trial and seeing what the people are talking about. Okay. Then we get to Brennan's recross. Was it recross? I keep getting twisted around. I think it's recross. He already crossed him. Talk to anybody about the defense's case. Did anyone weigh John O'Keefe's arm? You know where you got that, right? Where do we get it? They keep going back and forth. Isn't it important to use statistics and to be precise? Well, where do we get that 11-pound number? Do you really not know where we got that 11-pound number? And it was, kind of an aha moment for Brennan, I guess. I didn't really think it mattered, but here's his aha moment about where he got the, 11-pound weight for the arm.
This 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11? Is that the first time you heard of it from anybody? 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you, where did Brennan get those numbers from? You said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8 or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony. 11 pounds. Your prior.
I mean, he took the sting out of the aha moment. He's like, I believe I'm the one who said it. And he's like, that's right. It was your testimony.
Testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm. Based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct. Yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right? And so when you feigned confusion on Friday about this 11 pounds,
When you feigned confusion on Friday, I mean, honestly, the defense lawyers are being very calm because at this point, this long into the trial, and be like, Judge, I'm sick of it. He's doing it with every witness, every chance he gets, throwing in comments he knows are inappropriate. Like that to me, we're going to talk prosecutorial misconduct, but I'm just telling you, normal prosecutors that I used to try cases against when I did a lot more criminal defense than I do now, I would have argued to the judge, that's prosecutorial misconduct. They are knowingly making statements and asking questions they know are inadmissible and inappropriate. That is prosecutorial misconduct. They cannot do that. And I mean, we haven't even gotten into the actual prosecutorial misconduct today, but prosecutors are held to different standards. And I'm going to point that out with some of the stuff Yannetti does in his questioning. I don't really care if you like it or not. Prosecutors and defense lawyers have two different jobs. They're there for two different reasons. They're allowed to ask different styles of questions. They make different points. They poke different holes and prove things differently. That, to me, throughout this trial has been such a problem with Hank Brennan. He continues to do it, and it's disrespectful and it's inappropriate. Now, I'm not going to get my panties in the water or anything, right? I'm not going to go crying, but I'm going to be like, Judge, once again, how many times have you had to instruct the jury to strike a question as argumentative or inappropriate from the prosecutor?
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from. So,
Well, we just did the math, didn't we?
yes,
Okay. And you used a calculator to help you, didn't you?
I did. Yes.
Calculator works.
Yes.
Okay. You said you
Your calculator works, right? I'm going to jump ahead a little bit more.
Up to 29 miles per hour to account for that difference in weight.
were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
Like, are you trying to mislead this jury, sir? That's what he's trying to ask him here.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You use a weight that was lighter than Mr. O'Keefe's estimated arm.
Right. Because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with
Okay. Human arm is softer than a dummy arm. Decent point there, potentially, depending on how the jury takes it. First time you've ever discussed clothing as an expert, it's like, reaching there a little bit. Then he starts asking about Rentschler's report versus his report. And he's like, well, you didn't differentiate who's writing what parts of this report. There's 3 people. There's a Mr. Klein. Yet the Commonwealth is the one objecting to and making sure there's no cumulative testimony overlap and that they only called 2 ARCA witnesses and not 3. Those are arguments the Commonwealth has made throughout the pendency of this entire case. And the judge shut that down quick when Jackson objected to it, because it's like, you can't have it both ways. You can't say you're not going to testify to this and judge, he can't be able to testify to this. That would be cumulative, because the judge said only one of them can, they have to like separate what they're testifying to, no overlap. That's appropriate. That's normal with experts. That's what the judge said. But Brennan's trying to use it against Wolf by saying, oh, all this stuff over here, you can't testify to. He's like, yeah, that's what Rentschler testifies to. And he tried to use it as a knock in front of the jury, which again, it's just inappropriate. Can't do it. Then there were some very confusing questions about when the car hits the arm moves, the car moves, how fast does the arm move? He's trying to say that the light can touch the arm long enough to explode and scratch the arm. Wolf wasn't giving it to him, and it was very clunky, in my opinion, him trying to get that. Let's listen to last couple chunks here before this recross is over.
Correct. So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
Like, that seemed like Hank Brennan was almost trying to make a joke. He's no dummy. Randy crash test dummy. He's no dummy. Wolf almost laughs, and it's almost like, what are we doing here, man? Like, are you mad or are you making a joke? Because it seems like you're mad most of the time. Why are you so mad? What is that? That's like an Eminem song. Like is that Stan or something? I don't know.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis view, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate studied crash test dummy, is he?
I don't agree with that, because again, we use that type of dummy in all different types of tests.
There's an H395M PED thing near his shoe.
They go back and forth on, is it a dummy, is it not? Now we're going to jump ahead to, again, this was, I think, the best point by Hank Brennan on cross to point out these fragments near the body.
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Did you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Do we have the exhibit before, please? Can you tell from here?
Yes.
And finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No, it's possible.
Well, according to this, it's probable, yes?
In this test.
Oh, Brennan, be careful, brother. When you start saying what happened in this test, that it's probable, so is it then probable that it takes this much speed to crack the taillight? Is it probable that if you hit somebody at 25 miles an hour, the back of the Lexus is going to be destroyed and the back window is going to be shattered? Is it probable that it still wouldn't rip the sweatshirt? Is all that probable? Are you now saying everything that happened in these tests are probable? Ooh.
That did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
All right, before we get to Hank Brennan's last line of question here on cross, I'm going to answer some questions. Cleanse and fire. But Stan, why are you so mad? Try to understand. I think it's something like that, right? If Karen Reed is convicted and the defense files an appeal, will the appeals court consider the accumulation of adverse rulings, or do they need to deem at least one ruling so improper that it alone would overturn a verdict? So they're not going to look at the cumulative effect unless that's one of the reasons. Defense lawyers pick the biggest problems. They write the appellate brief. They explain why the problems, depending on the rules and the case law and everything in that land or commonwealth, if that rises to the level of a new trial or dismissal, potentially, depending on what happens, they're going to pick the rulings. The appellate court doesn't just like read the entire transcript of the trial. Dan, hey, Peter, my mom, sister, and I watch all the time. It's my sister's birthday. Can you tell Nikki, happy birthday, Nikki, and you rock, Dan. Bev said, jury seems ready to get the case. I thought she said, I wrote down what she said. The jury has like had enough or something, or has had it, meaning the jury like wasn't happy. And I was like, uh-oh. Hey, Peter, any chance the judge may have a hunch that it's been decided by the jury? Her demeanor was especially harsh today. I don't know. It was a stranger than usual vibe, like just get it over with. Well, she had to do a lot of work today. Sometimes judges don't like that. But this is one of my, beefs with this case from the jump, and how Brennan has kind of handled it is he's trying to not let the defense put on a defense. And when you do that, it creates a lot of motions and a lot of arguments and a lot of sidebars and a lot of voir dire, and that creates a lot of delays. And that's exactly what happened today. Does Bev have grave concerns now? I mean, she definitely should. B didn't make a mistake about the sweatshirt. He's slimy. Thank you for Peter for being you. Peter, can't the defense ask for an instruction regarding other law enforcement? My friends watching think feds investigated Karen Reed. No clue feds investigated law enforcement. In fact, Devers made it seem was so bad she elevated to FBI. I mean, no, that she's not going to give them an additional instruction that way. But I mean, if they really think about it and put it together that the feds or this other agency hired ARCA, and this is what ARCA said, even if they were investigating Karen Reed, it looks like they cleared Karen Reed. But it all depends on how individual jurors look at it. Is the prosecution allowed to meet with Judge Cannoni off the record during the trial? Absolutely not. That happened in another trial and created major problems. I feel like they are. I also feel like some of the breaks have conveniently timed to give Hank Brennan time to gather his thoughts. Was the judge's decision fair and just today? Okay, I'm going to hold this question. I see this. Do you think the defense should spend more time on the chain of custody issues? How long Proctor held onto the closing? Is that clear to the jury? No. I feel like they've spent a lot of time on it, but again, I watched trial 1, so you guys would be a better barometer than I would for that. La Posada is not an expert. Okay, hold on. I'm going to hold that one. Can you say happy birthday to Nikki? Yes, we got that one. Have you exchanged opinions with Brett and Alice from Prosecutor's Podcast about this case? I have not. I have not spoken to them. Brennan implied he had ulterior motives. Does that open the FBI door that neither side hired them? No, that's just normal credibility stuff that you can attack for sure with this type of witness. Okay, so now this is what, and anybody that wants to tell you this is not important, Brennan is a good lawyer. You guys are going to disagree with that. He's a skilled lawyer, I should say. Good, maybe I should be careful with using that word now after some of the antics today and some of the antics with his questions. But he's a skilled lawyer. He's a skilled advocate. I think he probably produces results. I don't know him personally, obviously, but I would not be surprised at that at all. And a skilled lawyer who makes plans and prepares, knows what he's doing, and he ends on a strong point. Good lawyers end on strong points. And so this is what he ended his recross on. This was intentional. He wanted to end with it because he thought it was a home run, big time point.
Did you ever look at the back of the sweatshirt to see if there was any holes?
Did you ever look at the back of the sweatshirt and see if there were any holes on the back of the sweatshirt? He's kind of far away from the mic. That's why I'm repeating it.
Sweatshirt other than the right arm, in form of your opinion?
I don't recall.
Take a look at the back. You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better.
Ollie Dan, it was definitely part of what he considered. Not all of it, but he definitely looked at it.
I'll direct you to here. You see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
He's like, I see one hole there. Brennan's like, well, let me direct your attention. And if you notice, and this is hindsight now, we're watching it after we know what happens. Jackson and the defense table, the way the courtroom is set up, they can't see it very well there. Did Brennan do that intentionally? Did he not hold it up back where the questions were? Wolf said he could only see one, so we had to bring it closer so we could see all the other ones, and then he puts it back away behind Wolf.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again,
He looks back at it, and this is where I give a nod and I tip my cap to Dr. Wolf. He is a very good expert. And when lawyers have a good expert on the stand, they trust him and they've got to get out of some battles themselves. We're not going to be able to help you. So it's like, we didn't prepare you for the back of the holes on the sweatshirt. We'll talk about why. But Wolf's got to answer these questions in front of the jury. So he's like, well, listen, Brendan, I'm looking at these holes. I didn't look at them. I didn't consider them. But guess what? They're just not consistent with road rash. They don't look like the holes we just looked at on the crash dummy. And he handles himself pretty well with an impossible situation, and we'll figure out why it's impossible later.
to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
There's multiple questions about it, every which way, his very last line of question. Then Jackson gets up and he's like, somebody else used the 50% drop test. Judson Welcher doesn't know the size of the taillight pieces, never a defect in the garment from the taillight. And he ends by saying the Lexus was destroyed in that final test. So again, a good redirect, whatever it was. Then Brennan gets up and again tries to get him into the taillight moving and the arm moving, et cetera, et cetera. Then we have a recess. We're going to have the voir dire of La Posada. And is this when it happened or did it happen later? Because I got to be honest with you. When they did the voir dire of La Posada, I barely wrote a note down. I listened to it and I was like, oh, this seems pretty simple. She is obviously an expert that can talk about this stuff, dog bite expert and ER doctor. Now, what I did say to myself is Cannoni going to take the out and say, I said one expert per specialty, and we've already had Russell talk about the dog bite. If she wants to come be the ME and talk about hypothermia and the head injuries and whatever, that's fine, but she's not going to talk about the dog bite. I thought Cannoni had an out to not allow La Posada to talk about the dog bites because it was cumulative. She did not say that, and we'll hold my thoughts on the ruling she made because I thought this was one of the easiest calls of any expert on the trial with the experience that she had to be able to talk about differentiating motor vehicle accident for dog bites. Because people, I don't know if people understand, when you get a really severe, serious dog bite that you need patched up, where do you go? The ER. Okay. And when you see these injuries and somebody dies from a dog attack, where do you go? Who looks at you? The ME, pathologists, forensic pathologists, if there's a case. So like, how do you become a dog bite expert? Like, you just go around taking pictures and looking and writing articles on it? No, doing what Russell and La Posada do, my opinion. But we had other fireworks. We have other fireworks to get to. And that is right after that line of questioning, basically shortly after we come back from a long break, the defense says, Judge, we need to talk to you. And Alessi says, I got to put my evidence gloves on. Did I mistime this? Because I had it at, here we go. I think some of my timestamps may be off, but that's okay. Alessi has to put on the gloves, come to the podium, and loudly and vigorously make another motion for mistrial. That's him putting on the gloves of justice. Here we go.
Moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie in this regards, questioning and representations and questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
The specific title.
Throughout these arguments, because it's pretty long and I want to play most of it, I'm going to skip a lot of the when they mark things and when they're walking around and not saying a lot. I'm going to skip through a lot of that, a lot of the fluff, but I want to get the majority of the arguments for us to discuss here because this is a big deal and the La Posada is a big deal. 2 major appellate issues. I've seen people saying, oh, this is for sure going to get overturned. And I think there's some major problems and some other things that are going to be fixed with legalese that you guys are not going to like probably, but I'm pretty confident in when it comes to the La Posada ruling at least.
Aisle holder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Righty.
If I could please have the next.
Back of the sweatshirt.
That's,
Just give me a minute to read this, Mr. Leslie.
yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why, for identification appears to support that.
So the judge is being confronted with irrefutable evidence that what Alessi is arguing is absolutely true. That there were no holes in the back of the sweatshirt. Okay, yeah, in case anybody didn't know, thank you, chat. This is outside the presence of the jury. The jury is not there. They're making an argument for the judge to throw this case out. So the judge is like, it appears what you're saying is true after we just heard a few minutes and multiple questions and the ending hammer of Hank Brennan on his recross. That was just completely false, what he said. There were no holes in the sweatshirt after the alleged accident.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
First time I realized that.
So if that alone was the issue, okay, I'm gonna try to see this as fairly as possible, regardless of how angry I might be about prosecutorial misconduct. But here, let me just tell you, if that was the only issue and you didn't show it to him, it's like, okay, it's already been in evidence. We've both used it. We've both looked at it. We both know what it looks like. So it's not like it was a new piece of evidence or something new that they were going to bring in as a demonstrative aid. But if you're going to use it and you're going to ask about something specifically and it was planned, I'm telling you, I'm not going to say Brennan planned on doing all the slimy, shady stuff, but it was absolutely planned for him to end his cross-examination on this topic and didn't bring it to Jackson's attention. John said, I believe Hank didn't intentionally lie, especially since he stood up and admitted his mistake. Additionally, I think it appeared much worse to the public than it accurately conveyed to the jury. I completely disagree with you, John. So it wouldn't be the first time we disagree. But I'm not going to say, I don't know what Hank Brennan's intent was, right? I'm not going to say he did intentionally do it or didn't intentionally do it. I completely disagree with you that it is blown out of proportion to the public. And I disagree with you that it was accurately conveyed to the jury. I hope, and John, I'm not going to say this because some people are going to take it. I'll say it because I know John. I love John. I appreciate John always being here. I love his different perspectives in these scenarios. I hope nothing like this ever happens to somebody you love where a prosecutor does this to them. Because mistake or not, this needs to be blown out of the proportion in front of the jury so they can understand and see what happened. And it can be absolutely clear that this was inappropriate and the prosecutor was dead wrong. because they need to know it's possible that that happens. And it's happened multiple times. So I disagree with you about the second part. I don't know about intent. I'm sure everybody's going to say he intentionally lied. I don't know that. And chill on John. Don't go off on John. He is one of the calmest people that disagree with a lot of people in this chat. And I want that. And I want to continue to be open to other opinions and views of what's going on in this case. If we lose that, we lose objectivity, and we don't want to lose people like John who can respectfully disagree, just like I will respectfully completely disagree back with him. We got to be able to do that. Just telling you, we got to be able to do that.
Okay. Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So,
frankly, I would so much rather talk to John about it than somebody being like, how naive can you be? Please, dude. It's like, brother, I've seen stuff, okay? Been through stuff. We can agree to disagree on what we think we know and what we can guarantee in life. And I know there aren't any guarantees in life, and I'm not going to accuse somebody of intentionally lying if I don't feel like I can have absolute proof of that. Do I think it's possible he lied? Yeah. Do I think it's probable that if he didn't lie, he was acting with reckless disregard for the truth? That's probably where I would land. That he didn't care if it was a lie or a truth. He wanted to go in. He thought he had a point to make, and he went and made that point. But you need to make sure that you're doing it right and you're being honest and you're giving honest portrayals of cross-examination questions when you're basically trying to catch a witness in a major problem. But like, relax, okay? Relax. I'm not trying to be, what did he say? I'm not trying to feign ignorance here, okay? So just relax. Relax, everybody.
Put in order. Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely,
Mr. Leslie. Okay. All right, thank you.
And I'm going to get to back to this in a moment. But I would like
Very clear. These are the holes cut by the criminalist doing testing on the sweater.
to do it and certainly entertain any of your questions, but in a logical order.
Sure. So I'm not, what about the jurors and lunch? How long do you think this
Harry,
will
that's a good point. I shouldn't scream relax. That's a good point. Point taken.
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back.
Just quickly, if you want to know the difference between with prejudice, without prejudice, if they win a mistrial without prejudice, they can refile. They can try the case again. Nobody wants that. Mistrial with prejudice, this thing is over.
Back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said when you said obviously cut by the criminalist? Do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie. I believe is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of.
I don't know if I agree with that. I think Hank Brennan might have still done it even if they were in evidence, because the hoodie was in evidence, right? I mean, so it's like, and we already heard, I think the criminalist did testify that's exactly what she did, and he still did it.
The intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top, LIMS 22-2184, analyst MSH, which is the initials for Ms. Hartnett. Dates, May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the.
You know what? Can you bring it up to me, please?
I certainly can, Your Honor.
Shows the back.
Let me just make. Mr. Wolf, you print the back, and then, Your Honor.
How do you think Brennan's feeling right now? Because I'll tell you, so there was one trial where it was a civil trial, and the lawyer was like, oh, we've got something. And I was like, oh man, what did I miss? Did I miss something? And he had something that was like a literal nothing burger. But I remember when he was telling the judge, we've got something big, judge, we need to talk about. I was like, crap. So I can only imagine what Brennan's feeling in this situation.
Are you comfortable using the computer or the back? Because I think we just had the wrong one.
The other time I felt that way was in the criminal trial I prosecuted that I said was the one trial I should not have prosecuted. The crime did not match the factual scenario, and it ended up getting overturned on appeal because we won anyways. I was sweating because I thought we were going to get JOA'd. I thought the judge was going to acquit it and be like, yeah, this doesn't fit. But the judge didn't, and we ended up winning as a prosecutor because you can do that. If you're a good trial lawyer and you can go in there and fight, and you're the prosecutor, you got justice on your side, and everybody looks at that person as probably guilty, which is why you have to be so careful with that power. You have to be careful. Learned a big lesson that day.
Mark it though.
I understood. We will stand. He's printing it right now. At the front, back. Your Honor.
With your argument.
Thank you, Your Honor. Which we will mark will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than.
So that seems perfectly reasonable, and I'd be inclined to do
about.
Right, hold on. So I want to back up for this because this is an important part. This is an important part of lawyering. Okay. What Alessi says right here tells me two things. Number one, he kind of already knows what's going to happen. He knows he's going to lose this motion for mistrial, and he knows the judge is going to give some kind of instruction. But also, Judge Cannoni is looking for any out. And as soon as he mentions an instruction to the jury, she's like, oh, I think that's fair. I think we should do that immediately. Listen to this.
To give to the jury is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than.
So that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And
she jumped at that opportunity, number one. But number two, I think he hung his head here a little bit because he's like, dang it, I shouldn't have given her that out. Because what you want to do first as a lawyer is act like there's only one remedy, and it is a mistrial, and judge, everything falls apart if I don't get this mistrial. And that's what he started out with. But he knows what's going to happen. He kind of said it. She jumped at it. And now it's kind of like a foregone conclusion. It's just, as soon as I heard that exchange, I was like, so what's the instruction going to be? That's what we need to jump at. That's important.
And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and here's another document. The document for the have that court reporting and a vote.
Mr. Les. Thank
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have exhibit 88, which is the hoodie. So what Mr. Brennan did, and I'm now pulling exhibit 88, he holds up the back of the hoodie.
Heidi, did I say Batman hands or did somebody else? Because that's what I thought too. So I don't know if it's like osmosis happening here, but I literally thought Batman hands too. Why? I mean, black gloves doesn't mean Batman hands. Why is that popping into so many people's heads?
Which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes.
We're not scared.
In the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees with the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination.
I bet you he just loves this, by the way. I bet you afterwards he's like, that was so fun. That's what it feels like to me. That's the energy I'm getting from him as he makes these mistrial arguments. And the judge was even like, Mr. Jackson, Wolf was your witness. Why would Alessi make this argument? He's like, Judge, I'm going to go ahead and hand this one off to Mr. Alessi. He's going to handle this.
In sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, the Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right. So let's move along from
right.
that.
That's what
She's like, let's move along. We don't need to rehash that. I've already ruled on that. Shouldn't Brennan be reprimanded? He had to have known the holes in the back of the shirt were from the criminalist if he did his job. The court just glossed over the clear intentional misconduct SMH. So again, it was either intentional or a reckless disregard for the truth. He just didn't care. And as she continues to hurry up these lawyers, there's a bunch of questions like Christie's. Be honest. Would you want to try a case with this judge? Absolutely not. I would not want to. She is like a referee who wants to be the star of the show. She inserts herself way too often. She makes things way too difficult. She doesn't let the lawyers lawyer. And there have been multiple times where it feels like it's she and Hank Brennan trying to work together on a solution. And like, she's like, Mr. Brennan, I know what I think is wrong with Dr. La Posada's report or where I'm going to limit it, but it's your motion. So what are you going to limit? Multiple times I've felt that way. Kelly said, at one point today, I threw up my hands and said, just send it to the jury for the deliberations. No more witnesses since they're not letting her put on a defense. Thanks, Peter, for your breakdowns. Yes, it is. It's really frustrating. Bev is so biased. It's ridiculous. This is going on in front of millions. I can't imagine what happens when no one's watching. On another note, my son just stationed to Navy base in Suda Bay, Crete. Ooh, that's awesome. Thank you for his service. Thank him for his service. I don't hate that question of, if this happens in front of everybody, what's happening behind closed doors? Because that's really tough. I would hate to think what is happening behind closed doors. Was the FBI hired to investigate law enforcement Proctor or Karen Reed? What I've heard, and there's no like official, I mean, what it seems like from official documentation and reports are they were hired to investigate the investigation. Alessi mistrial, Bev lunch though. Thoughts? I don't love it. I do not love it. Peter, don't you think that Beverly Cannoni stops Alessi too many times? He's trying to explain. He's really trying to make a point. So I think it's okay where she's like, can I see it? Can I look at it myself? Because I want to follow what you're following. Can you tell me what you're looking at outside the presence of the jury? I get it. It's frustrating, but lawyers are used to it. We're used to being peppered with questions. We want to know what the judge is thinking and where we need to go. So I totally understand all that, but she gets into it way too much. Way too much. Wouldn't Lally have known to tell Brennan? You would think. You would think. There were more on... Don't you think Bev should have scolded Hank? She definitely should have said, Mr. Brennan, I have grave concerns about this. Here's the point. That's why don't do it to the defense. Don't go over and by the way, more comments made by Judge Cannoni that I thought were absolutely horrible are coming up later today. But that's why you just don't do stuff like that to the defense, because then nobody expects you to do it to Hank Brennan in this situation. But because you've publicly reprimanded and shamed the defense multiple times, you need to do that to Hank Brennan in this situation. Michelle, Peter, does it bother you how often the judge interrupts the lawyer's arguments? She never lets them finish what they're trying to say. So irritating. She does it way too much. Way too much. Should the judge have caught Hoodiegate? This is the second trial for her too. All EDB chat did. Glad I caught the live. Frankly, no. She should be sitting there waiting for the lawyers to tell her what the problems are. Right? She needs to let the lawyers do their jobs. Now, if she notices it, she better call it out. If she doesn't notice it, it's not going to be on the judge at the end of the day. All right, let's listen to more of the argument.
And I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision.
And this is not really an argument for mistrial. This is not really an argument for the judge. This feels like an argument for the public.
The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you?
He's absolutely right about this, though. So the fact that they have no case, Judge Cannoni's not going to consider that, but the fact that it was absolutely used in a continuation to poke holes and say Wolf didn't do his job, didn't have all the information, didn't consider things he absolutely should have considered, that's the prejudice. That's what makes this such a problem.
Be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes. Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony.
Oh, I could. I could come up with more misleading and misrepresentations than that, but I get his point.
Than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall.
And here's where it comes in, where what I always say and people get annoyed about, where it's like, you don't know what a jury thinks. You don't know what they remember. You don't know what they consider. You don't know what they find important, right? As lawyers, we do our best. We try. Chat helps big time. The public helps big time. And that's a tool that, you know, a lot of lawyers never had throughout all their trials, and coming up and learning. It's just very, I mean, these are board certified criminal defense attorneys that are the biggest attorneys in the state of Florida that were here. And they're all like, oh, learning, right? From a civil lawyer, right? I mean, my dad's a criminal defense giant and king, and, you know, I've done plenty of criminal defense, but they're just writing it down. Some could call it a YouTube lawyer, right? This loser who's on YouTube, right? There's some lawyers that I'm sure back in the day would have said something like that. And I can't explain to you enough how important what Alessi is saying is, because we're not calling jurors stupid. What he's saying is, Judge, we don't know what has already stuck in their mind. They just heard the end of that cross where Brennan's like bringing it home, where you didn't do your job because you didn't consider these holes on the back of the sweater. Did that pull a juror into the guilty camp? Were they like, discredit this witness? I can't trust him. I can't listen to him. I won't listen to him. It's over for him. I'm moving on. So regardless of what the judge says, when they're like, hey, jurors, I need to unring that bell and put the toothpaste back in the tube. La, la, la. Men in Black, pretend like you didn't hear that. That doesn't always work. That is clear. That is factual, that does not always work. That is not always enough. And we can't take that risk. Karen Reed should not have to take that risk because he chose to go down that line of questioning and be dead wrong. And frankly, whether it's intentional or reckless disregard, it doesn't matter. He chose to do it. He made the mistake, and he should eat it. Karen Reed shouldn't eat it. That's what's so important about this. And it can't get lost just because somebody says, well, you know, we talked about it in front of the jury and, you know, we fixed it. And if you are going to do it, if you're going to make an instruction, it better be a lashing to the prosecutor. It better hurt the prosecutor, just like what he said hurt the defendant.
All the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard.
People don't like that, but that is true. That is correct. The defense does not have to put on evidence that's bad for them. They don't have to present any evidence that's bad for them. The prosecutors are supposed to present everybody that has information, witnesses, not necessarily bad information for them, but like they should have presented Barrows. They should have that's why we talk about the prosecution should have presented these witnesses and they didn't. Nobody's going to say that about the defense. That's burden shifting. They don't have to present everything they have. Prosecutors have to present everything they have, but I think you catch my drift of what I'm saying.
Justice.
By the way, we've been here an hour. We still got some ranting and some things to say. And the argument you're probably going to disagree with is still coming. So everybody feeling like, you know, they're gassing me up at this point. Just wait, because I think you're going to disagree with something. But I think after I explain, you'll at least understand where I'm coming from when it comes to the ruling on Dr. La Posada. So hang with me for that.
To create a fair trial.
And hit that like button. Just click it.
This is the antithesis of a fair trial. Ms. Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Miss Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
And you know, that could be for the cameras, but it's also very true. The public watching this is what prosecutors are doing. It's not good. Not good.
All right, thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be curative instruction. There should be.
Hear that? It appears I've made a mistake. Sassy said, Peter, I have to observe that at the beginning of the trial, you hesitated to criticize the judge. Now you are more willing. Is it because the accumulation of everything that has happened in the case? Here's what I'll say. When she does something bad, I criticize her. When I don't think she does something bad, I'm not going to criticize her. When she does something good, I'm going to say I think it was a good call, right? Generally speaking, I would hate to try a case in front of her. She seems very much leaning towards prosecution. I've seen judges in a lot of courtrooms that are heavily in favor of the prosecution. And it feels like, you know, it's 2-on-1 against criminal defense attorneys. I even felt that way sometimes as a prosecutor, where I was like, here we go. You know, I got the power of the state behind me. So I'm going to call like I see it. And this is, to me, I am more frustrated and feel, I don't know what the word is, angry is not the right word, at Hank Brennan than I am at the judge. Because I think, well, I'll hold until we get to her ruling when I tell you what I think a lot of judges would have done in this situation. But I don't think a lot of prosecutors would have done what Hank Brennan just did, even the bad ones.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
So he's like, Judge, I was wrong. I made a mistake, which I'm glad. Okay. We're going to give kudos where kudos should be given. If you want to call it intentional, whatever. And he only admitted because he got caught. Well, I've seen him say, oh, that wasn't not true. You know, they've said things that weren't true either. And it's like, dude, you definitely said something that was not true. So at least now he's like, hey, I made a mistake. And he's asking for the best case scenario for him, which is like, just give him an instruction, Judge, which is what she does. And have you ever seen a quicker argument from Hank Brennan? And he didn't mention anything about Alessi yelling. He didn't mention anything about Alessi grandstanding. He didn't say just because you yell loud doesn't mean you're right, which we've heard him say before. None of that. A little humble pie for Hank Brennan.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B.
Now we're going to listen to some discussion about what this instruction is. And I start thinking to myself while I'm listening to this, and I'm like, pause work. I go over and I'm like, what would I want this instruction to be? And I would want this instruction to be, members of the jury, Hank Brennan, the prosecutor, was wrong about the holes in the back of the sweatshirt. The Commonwealth's witness, the criminologist named whatever, testified that she cut the holes in the back of the sweater. These two exhibits show what the sweater looked like after the incident occurred at 34 Fairview. As you can see, there are no holes. Both sides agree this is the condition of the sweater after the alleged incident. They have their own theories of how it got into this condition, but this is the condition. Those holes you see are from the criminalist. And this is why it's really important, members of the jury, when we tell you what to focus on and what not to focus on, because even the lawyers can make mistakes because some of the evidence has been altered due to testing. And that's what happened here. And Hank Brennan made a mistake. He was wrong. I'm striking all the questions and answers that have to do with the holes in the sweatshirt. So you should know none of that has to do with Dr. Wolf's testimony. None of that should be held against Dr. Wolf. Strike all of that testimony from your memory and consideration in judging this case. Something like that. That's what I would have asked for. Sorry if it hurts, Hank Brennan. Sorry if it's prejudicial for you. It should be, because you created this mess, so you should be the one with dirt on your hands at the end of it, not Karen Reed. Not Karen Reed. And of course, people in the chat are like, that's not good enough. It wasn't a mistake. She should say he intentionally lied. That's never going to happen. I'm trying to be in the real world. The instruction that I gave, I think, is absolutely reasonable. I think that's an absolutely reasonable instruction. How's Hank Brennan going to argue about that? But let's hear their discussion about the statement she makes. And what I'll also say is, this is kind of weird. When something this big happens, every time this has happened in a trial like that I've had, and not necessarily even to this level of bad, but when there's a big statement or correction the judge needs to make, and it's something bad happened for my client and she's correcting the record, I want to draft that myself, Judge, and give it to you. And if they have an objection, put it on the record. If we can work together to come up with a statement. And Judge, I don't really care if you like it or not. If we agree, read the statement. If it's legally wrong or insufficient, fine. But I want to draft the instruction myself, Judge. If you're not going to give me a mistrial, I don't care if the jury has to sit and wait. Give me 5 minutes. We need to do this right. Karen Reed's life is on the line. I want to write the instruction myself. And they didn't really ask for it. She didn't really give them a chance to. It was all rushed. We'll listen to that.
4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury. And I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. He
didn't imply, and he didn't say perhaps they came from events. That's the problem. He said you didn't do your job because you didn't consider these holes when he shouldn't have considered these holes, and he did do his job, and Hank Brennan should have known that. His own witness made those holes. And we know what the sweatshirt looked like because we have the pictures. This is so much simpler than they make it.
instruct you.
Let's just tell the truth. Is that a novel idea? Let's tell the jury the truth. I would have liked that.
Are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside.
And that's getting close. I would still want more, but listen to how vastly different that is than the actual instruction she gives.
Can I see those, please?
Because she talks about, I am instructing you, those holes were made by the criminalist.
It's unclear for me. Do you have a better idea, Mr. Leslie, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates?
Your Honor, Honorable May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's right.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? You're right to save regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps further instruction for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up. Because that's what
Okay.
happened.
Yes. Yes.
These holes-
Yes.
By the way, this is how you know the defense has a legit argument. Because they're like, okay, you want an instruction? You can have an instruction. Here's the instruction. Okay, you want to hold up the hoodie sweatshirt? Here, hold up the hoodie sweatshirt. We're not going to give you a mistrial, but we'll give you a lot of things. And now is when you have some leverage to ask, which is why I would have said I want to draft the statement you give, Judge. Because when you do it like they did it, a little piecemeal, a little verbiage, a little audibly or orally, and she's writing it down, and you don't know what she's writing it down, and wait till you see what else happens. Where Judge Cannoni feels a little disrespected here in a second.
Yes.
Thank you. So that's number one as part of the stipulation. And then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree.
Well, it's only more forceful if you say the right thing. Word said, what does the judge mean? Your rights have been protected. That means it's all on the record. If you want to appeal it, if I'm wrong, the court will overturn this. So your rights are protected. It sucks though, because once you're in the appeal, it's so hard to win. But lots of judges say that. And, you know, they're like, well, if I'm wrong, the appellate court will fix it.
Not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that that rock wasn't present. You know, on
I mean, that's kind of a confusing statement to give the judge, because she did say those holes came from the criminalist. That's what she already told him she was going to put in the statement.
about time ago.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, 20. So all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can.
I mean, you've got to have more patience and a thicker skin than that if you're the judge. If they're not listening to you and they're turned around and you say it on the record, it's been typed out. But it seems to me like somebody turned their back, and we're going to hear Jackson apologize, and that offended Judge Cannoni. She's like, fine, you're not going to listen to me, then forget it. I won't even tell you what I'm going to instruct. It's like, whoa, you can't do that. I don't care how annoyed you are at me. I represent a criminal defendant. She has rights. It doesn't matter if your feelings were hurt. You have to tell me the instruction, because if we object to it, Judge, if we object to it, we need to put that on the record. So the fact that she, you know, her pride was hurt or something, that was another one where it's like, whoa, take it easy, Judge, relax. We're sitting here talking and working as a team.
Were a result of the events on January 29th, 20. So all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what.
Mama Zone, I guess it's good the criminals took the pictures in the case, took one of the pictures in this case that showed she actually did her job correctly. Yeah, it's crazy when you follow the rules of how you should document things before and after. Nobody can accuse you of planting evidence and doing things wrong. Like if you take a picture at the scene with Barrows, if you're Buchanan and Proctor, that changes this case, doesn't it?
What I said, Mr. Alessi. He said it. All right, we can bring the jury in. It's what I said, Mr. Alessi. Okay. All right. So it's what
Jackson's like, and Jackson, guess what? He's not in any kind of measuring contest. He's not going ego for ego. He's like, Judge, I apologize. I was consulting with Mr. Alessi. I did not mean to show any disrespect to the court. How do you think Jackson really felt when she said that and did that? Right? But it doesn't matter how you really feel. As a lawyer, as a judge, you suppress that and you act professionally and as calmly as you possibly can.
what I said,
And by the way, when she's saying things like, I'm going to basically say what I say. I'm going to say what I said. It's like, well, that's not good enough, especially when it comes out the way it did. And I don't know if the defendants objected after the fact or said, we need a correction there, Judge. You didn't do it right. Because they should have. I don't remember hearing that. It's woefully short. You'll hear when we get there.
Mr. Alessi, I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
This is yet again where Alessi is trying to simplify it orally, and the judge is listening and trying to implement what he says. And I think she just misunderstands what he's saying. And this last exchange, if that's why I think she says something like, oh, that's easier. I can take all this out and simplify it. It's like, yeah, you took all it out and you simplified it, but you took out all the punch.
I can just leave that all out then and just say, Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring him in, please.
She's like, I simplified it. It's neat now. But too much.
You can stand there. You can hold it up. All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. That those holes.
All right, so here's the actual instruction, how it came out.
So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So.
That doesn't help Dr. Wolf. That doesn't help Karen Reed. And that doesn't hurt Hank Brennan. And it doesn't hurt the Commonwealth. That is not an appropriate instruction. It does not do its job. The point was to make sure everybody knew Dr. Wolf did nothing wrong. Strike, even Hank Brennan said that you should strike all the questions and answers about the holes in the sweatshirt. Even Hank Brennan said that was appropriate, and she didn't even do that. Woefully short, not what she said she was going to say, and I don't think she gave the defense an opportunity or enough an opportunity. Now, they did try to orally handle it. They should have asked, and again, I'm not saying I'm better than them or whatever. I hate qualifying that. Whatever. They're better than me. They're smarter than me, better lawyers than me, better trial lawyers than me. It's easier for me to sit here, armchair psychology, this, whatever, Monday morning quarterback. But what they should have done is asked to write their own instruction, give it to Hank Brennan. If they can't work it out, give it to the judge, and then she will work off of what they write. Because they're the ones that were wronged, and she was remedying a problem the Commonwealth created for the defense. Let me answer some more questions. Good night. We have so many, and I really want to dig into what they can do with this. Was the judge's decision fair and just today? Because it felt like she really showed bias against the defense, but I'm no lawyer. This decision specifically, the outcome of it, I will say, I think most judges in America would not have granted a mistrial over this. You may disagree with that, but I think most judges in America would not grant a mistrial over this, but I think they would have hammered the Commonwealth in an instruction. Most judges, I think, would have given the criminal defense a lot of leeway coming up with an instruction to remedy this. If you were the judge and you had the Commonwealth admit they made a mistake, would you agree it's a mistrial? What is the scenario where the judge in this case would ever call for a mistrial? If I believed it was intentional misconduct, then potentially, yes, I would. Why didn't Bev instruct the jury the way she said she would? Can the defense ask her to reiterate that in final instructions? They can ask. I would ask for her to correct it like right now. Tomorrow, I'd be like, we need a better instruction, judge, and I would ask for it. I'm going to hold on the La Posada discussion. Call me crazy, but Arco's testimony has demonstrated how John's arm was injured by the taillight. Guilty. I think a lot of people are saying how it's a possibility, like I mentioned earlier. Can the defense argue that the curative instruction is the literal definition of why chain of custody is so important? So there's more questions on coming up about what can the defense do with this instruction in closing. Welcher could have afforded a few crash dummies with what was paid, correct? Why didn't he? Well, they're expensive. Also, why does Brennan get to ask the same question when they don't answer the way he wants, but the defense is always move on? I don't know if I'd say always, but he definitely repeats questions. Will the defense be able to bring up Brennan's mistake regarding the back of the hoodie being torn in their closing? No telling what else he's being misleading about. There's more questions like this. I'll answer more of them or put them on the screen, but they can argue Mr. Brennan asked all these questions to Dr. Wolf about the holes in the back of the hoodie, yet the judge instructed you those came from the criminalist, their own witness. So what's going on there? They can do that, right? They can absolutely do that. But what they can't say is he intentionally misled, he made a huge mistake and he shouldn't have. They could have gone so much further and deeper into this problem Hank Brennan created if they would have had a better instruction. Hey, Peter, heading to Canton this week with my lawyer, gear. What did you think of Alessi and yes, or the mistrial motion? So I gave my thoughts on that, Joanne. I can only imagine what's going to happen with that. Glad Alessi mentioned that they would bring up Bev's hoodie instruction in the morning. Okay, She absolutely pulled the bait and switch with the defense on that. Okay, interesting. So they're going to argue that in the morning. Peter, today was so irritating. Rate on a scale of 1 to 10, how Brennan's pretrial promise has aged when he said priority 1 is to make sure Karen Reed gets full trial. Maybe a 3. Finally catching alive. Any thoughts on the grass stains on the jeans and torn pocket? No stains on the hoodie, though, like he was dragged from the armpits. Your observation? So I kind of feel like some of the pictures on the crash test dummy had those same stains on them. Hey, Peter, shout out to my sister Liz. She suggested your channel in the winter. When I started following Karen Reed, we now both watch you and have great discussions. Blessings. Simple, the arm did not go faster than the car. I agree. Only a point on the arm did. It's like when you throw a baseball in the hand may go 100 miles an hour, but how fast does the elbow go? Why did Bev not instruct the jury to ignore all the testimony about the false sweatshirt holes? She blew it. Peter, do you think it makes a difference to the jury that the testing on the dummy was done on the pavement when John O'Keefe's only hit on the ground? That's probably depends juror by juror. It's hard for me to say which individual jury will, or what an individual juror will say about that. Okay, let me see where I wanted to go from here. Okay, I think that's it. So then Teddeman testifies to the different distances. 65 feet from the driveway to the door, 70 feet from the driveway to the second door, 78 feet to the door on the garage. I didn't think he was groundbreaking, but it's foundational. The defense is going to make arguments later. And then we hear about Dr. La Posada's background. And I made notes like, this seems pretty simple. She's an expert. If the judge is going to allow this kind of cumulative testimony to Dr. Russell's, and then we get the judge's ruling here on Dr. La Posada.
I'm not satisfied that the court personnel waiting so that we could have that voir dire was helpful. All right, so my rulings are very similar that they were this morning. So first of all, on the Darbert analysis regarding Dr. La Posada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made.
Listen to how she says why. So it's very important that she made this decision not based on cumulative, because I think she said it before. It's how it would be here in Florida as well. And a lot of courts I've practiced in, you can't have two experts come and testify about the same thing. You can't have two dog bite experts as doctors, medical doctors, testifying to the mechanism and causation of injury is from a dog bite and not a car accident. Cumulative testimony, cumulative resumes and backgrounds. That's not what she said. And that's what you guys might disagree with. That's also why I think even if she got it wrong, if an appellate court is like, well, she's wrong, but it was cumulative, so therefore it's not reversible error. I do think that's possible on appeal for an appellate court to see it that way. No guarantee, and I don't know. I'm not an appellate court judge. I have done some appeals. I was on the moot court team in law school. But I think even though I think she made the completely wrong reason decision, I think there was a potentially right reason she could have kept it out, and maybe the appellate court will look at that. But let's listen. It's super interesting why she makes this decision.
Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert qualified to testify as to dog bite wounds.
Yeah, we remember. Barely just over the line. And you made it sound like she wasn't a very good expert and that there was a lot of fodder for cross. But she's now going to use Dr. Russell as the barometer as to why Dr. La Posada doesn't measure up. And also, if I was a defense appellate attorney, I may say the judge knew and was considering Dr. Russell and chose not to call it cumulative. So appellate court, don't make the argument for them. And the Commonwealth appellate attorney, you're making that argument too late. Because she was considering Dr. Russell when she made this opinion. She even put it in her reasoning, and she didn't consider or make the decision based on cumulative testimony.
Mainly from her experience, I found that Dr. Russell was an expert qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. La Posada does not.
Okay. So her resume was good enough.
Have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10,
So did you hear that last part? Dr. Russell was published. You don't have to be published to be an expert. In my opinion, it was so easily clear that Dr. La Posada was an expert on dog bites and car accidents and should absolutely have been able to testify to the dog bites and the car accident. If you compare her to some of the other experts, and the defense even said they had a neurosurgeon come and testify about this case, and he was testifying about how hard the ground is and all this other stuff. That's obviously outside his expertise. He was, of course, very, very great expert when it came to actually brain injuries and things like that. But we've talked about how low the bar is for experts. And that bar being so low, she clears it easily. Baba D, somewhat more forcefully, like I answered before, but not as much as it could have been. I don't know if Canoni cares or knows how she comes across. Some judges really do, some don't.
in 11, all of the text on Dr. La Posada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now, moving on to the testimony regarding not being consistent with a motor vehicle strike, I find that Dr. La Posada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all, in some regards significantly, like I said this morning. So
even that, she's even going to limit her testimony on car accidents. It's like, what? I don't get what you expect out of an expert, especially when I look at how some of the experts just let right in for the Commonwealth, right? And if you remember, one of the videos I did that, got a lot of backlash and whatever, is when I said it was a horrible decision the way that she compared, when I compared the two dog bite experts, Russell and Cosby, whatever his name is, and how she made those rulings and how obviously blatantly different they were. And we're seeing more of it come out here.
So on page 17, that first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is
I agree. She shouldn't be able to testify about that stuff. Not an accident reconstruction. She admits that. Shouldn't be able to.
out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot.
So to me, that's a little bit more than Russell, but could also be seen as cumulative, and the judge is going to let it in. That's good for the defense. And I do think that's incredibly important testimony that the jury is going to see and hear.
I'd say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in. And the next sentence, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me, it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. La Posada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There's no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry.
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to do it now.
All right. So you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in.
But that's what happens. And sometimes you need to have it. And frankly, it hasn't happened that as much this trial as the last trial, I believe, and as I've seen in some other trials. So it's like, relax. We had one day where we wasted the jurors' time. It sucks. We don't want to do that. We're getting close to the end. And these are big issues. This is our defense. She has a constitutional right to defend herself. And they're trying to pick it apart, and you're letting them. We need to take time to do this right.
That might just we have to finish that.
Right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I would do is I will go through that will take me a good amount of time. I will go through the part of her initial analysis that will not include any photos, but I may be able to actually go through the portion that it's very specific. And I would be as
Okay, so let
that as possible.
let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So
It was.
so
And he's like, you're letting some of this stuff in for the Commonwealth. She's like, that's not object to his big difference, being like, I don't make these decisions. You guys make arguments to me and then I make the call. He's like, it was objected to. So I expect more argument on that tomorrow as well.
we'll deal with this tomorrow, with the photographs
I
tomorrow.
just want to let the court know, not waste the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay.
He's like, we won, so we're good, Judge. We're good. Okay, before we get to Dr. La Posada, I'm going to answer some more questions. La Posada is not an expert, so egregious when you consider she's allowing a dog trainer to be a medical expert. It just seems like kangaroo court. I agree, she absolutely should be an expert. La Posada seems good, but isn't she cumulative? I think if the judge would have ruled her as cumulative and really limited her testimony just to like how the plastic fragments could or couldn't have made these injuries, you could be mad about it, but I think legally I could understand where she's coming from. Dr. L not qualified to testify on bites is wild. The FBI completed their investigation and found no criminal misconduct in the Canton Police Department or any other law enforcement agency. Will this be admitted into Karen Reed's trial? No, and it's not over. Like the FBI investigation doesn't mean it's over, right? Doesn't mean they can't reopen it. So we just have to be careful about how we phrase what happened with them. Why can't Bev tell the jury Hank misled them? Misled is probably never going to happen, but he was wrong, which he admitted. He made a mistake and was wrong with all those questions. I think that's fair game. Peter, what are your thoughts on whether or not the jury will hold it against Karen that Alan Jackson talked about Albert and Higgins, all the things in opening statement, but it never really came into evidence? I think depending on how he handles it in closing, that they're not going to hold it against him. And the missing witness instruction is going to be really important for that. Can they discuss Hank's mistakes in closing arguments? Yes, to a certain degree. Does the defense get to cross the rebuttal witnesses? Absolutely. Can the defense argue this misconduct in closing? To a certain degree. Whether Brennan actually knew or not, isn't it the duty to figure out, and there's a good faith basis for his questions before asking? Absolutely. That's why I'm saying, even if it wasn't intentional, it's a reckless disregard. Can the defense in closing bring up the Commonwealth as hid witnesses and misled you, play a Karen Reed clip in full context, and cast doubt on the rest of the clips? Only if it's in evidence, number one. Number two, they have to be careful about saying the Commonwealth misled you or hid things, right? If you read the missing witness instruction, that's about as far as they're willing or allowed to go. Peter, who do you think Hank is texting? Watch him text someone when Alessi makes his argument. And I also noticed that there is somebody else said he's on his phone. I'll find it eventually. But yeah, I mean, when I prosecuted cases and against a lot of prosecutors in Pinellas County, they're sitting there chatting with the home office the entire trial, giving each other information, helping each other. Most judges allow that. Why was he allowed to touch other things with the evidence gloves and then touching the actual evidence? Doesn't that contaminate the gloves? Yeah, I don't really know how all that works, right? Because I would think you have to be very careful switching gloves, whatever, not to contaminate it, or else, why touch the gloves in the first place? But I don't know. Just like HB drilled Dr. Wolf about whether he read Rentschler's reference articles and reports, did he himself not read the report by his own criminalist, or did he intentionally mislead? Good point. Have they ever brought up why wouldn't John O'Keefe try to get out of the way? I mean, he didn't see it coming would be the obvious answer to that. If, God forbid, Karen does get a guilty verdict, what kind of prison time would she be facing? We're going to look into all of that when the jury's deliberating. That's usually when we do it because people have a lot of questions and we do streams if there's multiple days of deliberation. So we will talk about that. Peter, the inconsistent rulings are driving me crazy. Surely there can be an argument that they have a cumulative effect showing bias by Her Honor. It could be something they appeal. Can the defense pass info to whoever's examining the witnesses if they come up with something on the fly during cross? Absolutely, passing notes and whispering in their ear. That's why you confer with counsel before you sit down. Caleb, do you think the appeals courts will agree with the instruction was enough, or is this reversible error? I think it could be reversible error. I feel like I've said that more than I should in this trial. Can the defense ask Bev to recuse herself, even if it's just for the record? Potentially, but she's going to say no. Will the judge be able to add to the jury instruction unless he said they weren't satisfied and want a motion for adding regarding the jacket? I think she can. I don't know if she will. I'm still stuck on last Friday when Bev said, maybe this time we can get an answer. Doesn't that prejudice the jury? Could it be used for appeal along with her other biased utterances? I don't know what this is in reference to, so I can't answer. I'm not sure. I don't remember when she said that. She didn't even bother to question Hank. Isn't that to be expected in a situation like this? Yeah. Did you intentionally do this? Let's do this in open court. Any plans to go to Canton before the trial ends? No. Mandy, Alessi should have told Bev he had grave concerns about what Hank did. Can he get reprimanded by the bar for this? Also ruling on La Posada was a joke. Potentially, but I mean, he said it was a mistake. They would have to find intentional misconduct. I'm a little behind, but Brennan read from his phone after Alessi. Here it was. Brennan being tapping on his phone just before he finished. He can do research on his phone. He can type out a note on his phone. He can talk to people on his phone, helping him with the case. Marianne, Peter, don't you think the judge should have let the defense witness testify to more than was allowed today? I'm comparing today's ruling to the Commonwealth's neurosurgeon testimony. What are your thoughts? Yeah, I do, but let's wait and see. Her testimony's in the middle, so we'll see what else she gets to do. Peter, are the limitations to the defense mentioning the holes in the back of the sweatshirt in closing? Example, prosecution lied. They're not going to be able to say they lied, but I think they're going to be able to do more than the instruction. I think it's important to see what they can do with that instruction tomorrow. So much today, but what was the most egregious decision Bev made today? I feel sad for Karen Reed not getting a fair trial with these people she's up against. By far, to me, it was the instruction she gave. Can the defense file an interlocutory appeal about the sweatshirt gate? I don't think so, no. And could Bev change her mind tonight and or give a further, more strongly worded instruction when she has more time to consider? I think the answer to that is yes. What if the prosecutor knows the defendant is not guilty? They have a legal obligation to stop prosecuting the case and dismiss it, or tell their boss, I'm out, just like happened in Alec Baldwin case when that prosecutor quit. The way she is rushing the defense makes me incensed. Thank God Jackson spoke up today when the trial is being, someone's life's on the line. Who cares if Bev didn't get lunch right at 12? Yeah, she's like, can we handle Rentschler's motion now? He's like, absolutely not, Judge. I haven't had time. What opinions do defense have to complain about Cannoni? A ton of them. And it could be cumulative error. They could pick the best ones in the appeal. Too late to remedy her super weak instruction? I don't think so. I think she can fix it tomorrow. Can they appeal the ruling on the coroner's testimony? Yes. Does the fact that she didn't read the agreed upon statement incorrectly raise a potential appellate issue if convicted? Yes. Today, along with many other days in this trial, I feel like I need a stronger drink than water. Don't worry. I don't live in Canton, so I don't drink and drive. That's a joke. Frustrated today. This takes today's incident in isolation. Brennan, Lally, and the Commonwealth have a pattern of mistakes, Sallyport, etc. Baldwin trial was a cumulative one. Can they make a motion that she did not close this right? If you mean make a better statement, I think they can. Why does Cannoni view sidebars or handling important issues as a waste of time? Someone's life's on the line here. I agree. But what she means is the jury sitting back there wondering what's happening and not knowing what's happening can feel like a waste of time to the jury, and we really don't want that. Didn't the judge also say she's going to admit into evidence the photos of the back of the hoodie, and she never did? She said she was going to. I'm not sure if she did or not. Can they bring him back up? Meaning Wolf? I don't think so at this point. But if they wanted to as a remedy, I think the judge would be open to further remedy of this issue. I could be wrong. I agree the instruction was seriously lacking. However, if I were a juror, the damage is done. I now find Hank Brennan noticeably insincere. I hope that's what they find, because that's the truth in this situation. I'm not sure the statement was strong enough to get that. Can he regain the jury's trust at this point? I don't believe he can. That's for the jury to answer. If I were a juror and heard that instruction, I would be confused and asking myself what happened while I was out. I agree. One more question, Peter. Did you notice when Hank got frazzled, he misspoke and said if a car actually hit an arm, Freudian slip, that he knows? Or he's just using appropriate language at this point because they haven't proven it beyond a reasonable doubt. All right, La Posada, let's hit this quick. Tons of experience. The chief ME for the entire state of Rhode Island, multiple awards, really great, cause and manner of death, goes through everything she reviewed in this case, starts getting into John O'Keefe's injuries. Let's listen to just kind of, one of the opinions that she gave, and then we'll end for the day on some more questions.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me in your.
So they have another sidebar, and we'll listen to how it ends up coming out afterwards.
May I inquire?
Yes.
Thank you. Dr. Laposada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again.
And that's where they ended the day. More medical testimony that that injury on his eyelid was separate from the brain injury that ended his life, and it could have been caused by a fist or another object. And that's how the jury ended the day. And so we still have La Posada. We have Rentschler. Is that it? Am I forgetting anybody? I think that might be it. And I mentioned earlier that I did want to mention Yannetti sneaking something in as a defense lawyer, which is, again, different from what a prosecutor can do. He's like, when his investigator went out there to measure, he's like, did you sneak a peek inside the garage? Concrete floor? Concrete stairs? Like a ledge that could have caused an injury to John O'Keefe's back of his head? That's what it felt like he was trying to slip in there, which, again, defense attorneys creating doubt, highlighting possibilities and problems, good faith basis, that kind of information has come out that could have caused the head injury, and that's what he was doing. Knucklehead, has the judge ruled on the missing witness yet? I haven't seen it. Couldn't it affect the witnesses the defense calls Proctor Higgins, or do they need to argue in closing? I agree with you. I think it does affect that. I haven't seen if the decision's come down yet. Do you think AJ having the doctor read her CV was an FU? It's hard to tell what's an FU at this point compared to some of the CVs and educational backgrounds of some of the Commonwealth witnesses. This is impossible to parse. They have to tell their expert that she can say irregular plastic but not taillight, but they can't lead. You just talk to her afterwards. You're allowed to do that and basically tell her what she has to say based on the judge's ruling. It's not as hard as it may seem. Can the defense explicitly call out Hank Brennan's burden shifting in closing? The jury might not understand what burden shifting is, but they can make an argument to the judge to make sure he doesn't do any more of it. And that could also be an appellate issue. That strategy of questioning is more dangerous, effective than the videos. Should have pushed harder for a better instruction, was so weak compared to the misconduct. Did they give up the appeal arguments by not fighting it harder? No, they didn't give up any appellate arguments. Concerned, she will deny the missing witness instruction, and the defense will lose an opportunity to call witnesses. Thoughts? I don't know. Let's wait to see what she actually does. Crazy how during the insane misconduct, the only party the judge admonished was the defense for something petty and not said to Hank at all. I agree. If they don't want to listen, that's their problem. But to take that personally is just, I have not seen a ruling on the missing witness. I assume Ashley would send it to me if it exists. Hank needs a spank. Old Bev is shutting down early so she can see to it. Last Friday, Hank Brennan was hammering Wolf over and over again on the same question. Bev said something like, maybe this time we can get an answer. I'm sure that's what she said. It was brought up on other channels. Well, yeah, I mean, that's inappropriate. She should not be making that comment. Now, I usually like to hear the context because sometimes I think people have misheard, or maybe it was different context, but she should absolutely not be saying that. Do you think jurors really forget once they hear? No, but I think if you said the lawyer was wrong, strike it all, this is what actually happened, I think that can be strong enough to change how they remember it. Spoiler alert, she's 100% talking to somebody in an earpiece. She covers her mouth and her lips and is literally, it's coming up. Keep playing. Alessi bringing up the Monty Python vibe. What is your favorite color? What is your name? What is your airspeed velocity of an unladen swallow? Would she be able to testify why no x-rays were taken? Maybe, but I don't know why you'd want to ask that as the defense. Judge gives the impression she worries about the jury's time, but she was looking at her watch today when the jury was gone and going through the pics. She's a piece of work. Gigi, what's your opinion on the judge saying the jury looked annoyed today? Do you think that indicates that this case has been a waste of time? No, but it does worry me about all the sidebars and the long breaks. And who does the jury think that is at fault for that? Do they think the defense is wasting their time because Alan Jackson has to ask for a sidebar, or the defense has to object again because something problematic happened and they request to approach? If so, that's concerning. And that's why I would like to say objection speculation, objection leading. I'd like to do my job as a lawyer judge. And you not letting me is making me call for more sidebars. So it could be concerning. I feel people are coping when they say Hank's reputation with the jurors is done. If I were a juror, I would assume from the judge's monotone instructions, it was a minor legalese issue, not Hank's misconduct. I agree. Jurors usually trust prosecutors and judges. So I agree. I think the public is quicker to jump to that than the jury is going to be. All right. I got to run. I love you all. Hit that like button, subscribe, click all the buttons, do all the things. You're the best. I appreciate it. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.